listen closely because what I'm about to share with you could be the difference between keeping your green card and losing everything you've worked so hard to achieve. USCIS has rolled out 5 critical enforcement measures for 2026. And mistake number 5 is causing denials that nobody saw coming. If you're a conditional green card holder, this information could save your future in America. Stay with me because by the end of this video, you'll know exactly what to avoid and how to protect yourself. Welcome back to US Info Updates, your trusted source for the latest immigration news, tips, and strategies that actually work. I'm here to cut through the confusion and give you the real information you need to succeed with your immigration journey. Today, we're diving deep into 5 devastating mistakes that could completely derail your green card application or status in 2026. The government has changed its approach. Enforcement is stricter than ever. And if you're not aware of these new realities, you could find yourself on the wrong side of an immigration decision. Now, before we get into the details, I want you to understand something important. This isn't just another generic immigration video. What I'm sharing with you today comes from real cases, real situations, and real people who have faced denials and complications because they didn't know what you're about to learn. So grab a notebook, turn off distractions, and let's make sure you're fully prepared for what's coming in 2026. Let's start with mistake number 1, and this one is absolutely critical for anyone who already has a green card in their possession. Extended absences from the United States are going to be monitored and enforced like never before. If you think you can just travel freely and spend months outside the country without consequences, you need to rethink that strategy immediately. Here's what's happening. The government is implementing enhanced tracking systems starting in February 2026. This isn't just about recording when you enter the United States anymore. Now, they're going to be tracking when you leave as well. This means USCIS will have a complete picture of your travel patterns, how long you're staying outside the country, and whether you're actually maintaining your residence in the United States as required by law. You see, having a green card comes with responsibilities. One of the most important is that you must maintain your permanent residence in the United States. The law requires that you consider the United States your primary home. If you're spending 6 months or more outside the country, you're putting your green card at serious risk. If you're gone for a year or more without obtaining a re-entry permit, you could be considered to have abandoned your permanent resident status entirely. But here's where it gets even more serious. In 2026, when you go through the Form I-90 renewal process for your green card, they're going to be looking at your travel history with a microscope. People who don't meet the residency requirements are going to be flagged during this renewal process. This could lead to requests for evidence, interviews where you have to prove you haven't abandoned your status, or, in the worst cases, outright denial of your renewal application. My strong recommendation is this. If your green card is coming up for renewal, start the process at least 6 months in advance. Don't wait until the last minute. Why? Because if there's a problem with your travel history or residency, you'll have time to address it. Gather evidence and potentially fix the situation before it becomes irreversible. Don't give USCIS a reason to question your commitment to living in the United States. Now, let's move to mistake number 2, and this one affects people who are currently in the process of applying for their green card. The Form I-485, which is your application to register permanent residence or adjust status, contains questions about public charge that are tripping up countless applicants. I cannot stress enough how important it is to get these questions right. The public charge rule is designed to ensure that people coming to the United States or adjusting their status will not become primarily dependent on the government for support. The questions on the I-485 ask about benefits you've received, benefits you're currently receiving, and even benefits you might apply for in the future. They also require detailed financial documentation to prove that you have adequate support. I've seen so many cases where applicants either don't understand these questions or they try to hide information and it backfires spectacularly. Let me be clear. If you've received public benefits, that doesn't automatically disqualify you, but failing to disclose them or providing inconsistent information absolutely can. When USCIS reviews your application and cross-references it with government databases, any discrepancies will trigger requests for evidence or even denials. The financial documentation component is equally critical. You need to prove that you have sufficient income or assets, or that your sponsor has sufficient income through the form I-864 Affidavit of Support. Don't submit outdated tax returns, incomplete bank statements, or vague employment letters. Every piece of financial evidence needs to be current, complete, and clearly demonstrates that you will not become a public charge. But there's another critical mistake within the Form I-485 that's causing major problems, and it relates to your entry records. There's a specific question that asks when you last entered the United States and what status you were in at that time. You must answer this question exactly as it appears on your Form I-94 arrival and departure record. This isn't a place for approximations or your best guess. Why is this so important? Because if the information you provide doesn't match your official I-94 record, USCIS will view this as a potential misrepresentation or even fraud, even if it was an honest mistake, even if you simply didn't remember the exact date. It can be interpreted as an attempt to deceive the government. And once there's a finding of fraud or misrepresentation, your entire application can be denied and you could face serious consequences, including bars from future immigration benefits. So, before you fill out that form, go online to the CBP website and pull your official I-94 records. Make sure every date, every entry, every status listed on your I-485 matches exactly what the government has on file. This simple step could be the difference between approval and a devastating denial. Moving on to mistake number 3. And this is something I see constantly in my work with immigration cases. Incomplete forms, inaccurate information, and missing documents are among the top reasons why applications get denied. And in 2026, USCIS is taking an even harder line on this issue. Here's what you need to understand. In the past, if you submitted an incomplete application or forgot to include a supporting document, you might receive a request for evidence, giving you a chance to correct the mistake. But under the current policy environment, USCIS is not obligated to issue an RF. They can simply deny your case outright if it's incomplete or if critical information is missing. Think about what that means. You've paid the filing fees, which in many cases are hundreds or even thousands of dollars. You've waited months for your case to be reviewed. You've invested time, money, and emotional energy into this process. And then, because you forgot to sign a form or didn't include a required document, your entire application gets denied. You don't get a second chance. You have to start all over again. Whether you're filing a Form I-485 for adjustment of status, a Form I-130 for a family-based petition, or a Form I-751 to remove conditions on your residence, every single line must be completed accurately. Every required document must be included. Every signature must be in place. There's no room for errors in 2026. This is why I always recommend that people either work with an experienced immigration attorney or at the very minimum have an attorney review their application before submission. Many law firms, including reputable ones across the country, offer unbundled services where they'll review your forms and documents for a reasonable fee. This investment could save you from a costly denial. With everything that's happening in immigration enforcement, with the additional vetting procedures, with cases being paused and scrutinized more carefully than ever, USCIS officers are looking for reasons to deny applications. Don't hand them an easy one by submitting incomplete or inaccurate paperwork. Triple check everything. Have someone else review it. Make absolutely certain that when you mail that application, it's perfect. Now, we come to mistake number 4, and this is about being unprepared for the reality of immigration processing in 2026. You need to prepare yourself mentally and financially for significant delays due to enhanced vetting, paused cases, and increased filing fees. The vetting process has been intensified across the board, but especially for applicants from certain countries. There are currently about 35 countries whose nationals are facing additional scrutiny in the immigration process. If you're from one of these countries, your case is going to take longer. Your application might be paused while additional background checks are completed. You might be asked for additional documentation or called in for additional interviews. This isn't meant to discourage you, but you need to go into this process with realistic expectations. If you're applying for a green card and you're from one of these countries currently subject to travel restrictions or enhanced vetting, understand that your timeline could be significantly longer than what you see published on the USCIS website. Plan accordingly. Make sure you have valid work authorization if you need it. Make sure your current status doesn't expire while you're waiting. There's also the issue of cases being re-adjudicated. If you filed an application anytime from 2021 forward, there's a possibility that your approved case could be reviewed again under current policies. This is particularly relevant for people who have already received their green cards but are now going through other processes like naturalization. Be prepared to provide additional evidence to answer questions about how your case was decided and to potentially face delays because of this enhanced scrutiny. And then there are the fee increases. Starting in February 2026, many immigration applications are going to cost more, in some cases significantly more. And here's the critical part. Unlike in the past, when there were grace periods allowing you to file with the old fee for a short time after the increase took effect, this time there will be no grace period. If you submit your application with the old fee after the increase goes into effect, it will be rejected. You'll lose time and you'll have to refile with the correct fee. So you need to know exactly what the filing fees are for your specific application and make sure you're sending the correct amount. Check the USCIS website regularly for updates. If you're planning to file an application soon, consider whether you should file before the fee increase takes effect. Here's another crucial piece of advice related to delays. If you have a pending green card application, do not travel internationally unless absolutely necessary. I know this is difficult. I know you might have family emergencies, business obligations, or other compelling reasons to travel. But the reality is that we've seen too many people get stuck outside the United States because of sudden policy changes, executive orders, or travel restrictions. In 2025, there were individuals who traveled outside the country with advanced parole documents, expecting to return without issues, only to find themselves unable to re-enter because of policy changes that happened while they were abroad. Don't put yourself in that situation. If at all possible, stay in the United States until your green card is physically in your hand. The temporary inconvenience of not traveling is far better than the nightmare of being stuck outside the country with your entire immigration case in jeopardy. And now we arrive at mistake number 5. The one I told you at the beginning was the most important, especially for conditional green card holders. If you received your green card through marriage and you're within the 2-year conditional period, or if you're approaching the time when you need to file Form I-751 to remove the conditions on your residence, you need to pay very close attention to what I'm about to tell you. The Form I-751 process is going to be enforced more strictly in 2026 than ever before. And there's a specific trend that almost nobody is talking about that could result in your case being denied even when you think you've done everything right. First, let me explain the basics for those who might not be familiar. When you get a green card through marriage to a U.S. citizen and you've been married for less than 2 years at the time your green card is approved, you receive a conditional green card. This card is valid for 2 years before those 2 years are up. Specifically, within the 90-day window before the second anniversary of your conditional residence, you must file Form I-751 to remove the conditions and obtain a permanent 10-year green card. Ideally, you file this form jointly with your U.S. citizen spouse. You submit evidence that your marriage is real and ongoing. And if everything checks out, your conditions are removed and you get your permanent green card. But what happens when the marriage has ended? What if you're separated or divorced? The good news is that you can still file the I-751 on your own using what's called a waiver of the joint filing requirement. There are three main categories of waivers. The first is the good faith waiver, where you entered the marriage in good faith, meaning it was a real marriage based on love, not just to get immigration benefits, but things didn't work out and the marriage ended. The second is the abuse waiver, where you were subjected to battery or extreme cruelty by your U.S. citizen spouse. The third is the extreme hardship waiver, where removing you from the United States would cause you extreme hardship. Now, here's where people are making a critical mistake in 2026, and it's resulting in denials. Some applicants trying to strengthen their case or unsure which waiver category fits their situation best are filing under multiple waiver categories at the same time. They might claim both good faith and abuse, or good faith and extreme hardship, or even all three. This seems logical, right? If you have evidence for multiple categories, why not present it all and let USCIS choose the strongest one? Here's why. Because each waiver category requires different evidence and different legal standards. When you file under multiple categories, USCIS evaluates each one separately. If they approve one category but deny the others, the denial of those other categories can actually result in your entire I-751 being denied, even though you met the requirements for one of them. Let me give you an example to make this clear. Let's say you file claiming both good faith marriage and abuse. You have strong evidence that your marriage was genuine. You have photos, joint bank accounts, lease agreements, affidavit from friends and family, but your evidence of abuse, while real to you, might not meet the strict legal definition that USCIS requires. Maybe the abuse was emotional or psychological, but you don't have police reports, restraining orders, or medical records that USCIS typically looks for in abuse cases. USCIS reviews your application and agrees that you entered the marriage in good faith. They would approve that waiver, but they find that your abuse claim doesn't meet their evidentiary standards. So they deny that portion. Because you filed under both waivers and one was denied, they can deny your entire I-751 application, you lose your conditional green card, and you could be placed in removal proceedings, all because you tried to be thorough by including multiple waiver categories. This is why it's absolutely essential that you choose only one waiver category, the one for which you have the strongest evidence and which most clearly applies to your situation. If you're not sure which one that is, consult with an experienced immigration attorney before you file. Don't try to hedge your bets by including multiple waivers. It's not worth the risk. There's another enforcement issue related to Form I-751 that's becoming much stricter in 2026. If you're filing with a waiver because your marriage has ended, you must be fully divorced before you file. This has always technically been the rule, but in the past, USCIS was sometimes lenient and would accept cases where the divorce was pending but not yet finalized. That leniency is gone. In 2026, if you file your I-751 with a good faith waiver and your divorce isn't final, your case will be denied. It doesn't matter if you've been separated for years. It doesn't matter if the divorce papers have been filed and you're just waiting for the court date. If that divorce decree isn't signed by a judge and finalized, you cannot file the I-751 with a waiver. You need to wait until the divorce is complete. Now, I know what some of you are thinking. What if your 2-year anniversary is coming up and your divorce isn't final yet? This is a difficult situation, and you need legal advice specific to your circumstances. In some cases, it might still be possible to file jointly if you and your spouse are on good terms and willing to cooperate. In other cases, you might need to let your conditional green card technically expire while you wait for the divorce to finalize, then file the I-751 with the waiver. After the divorce is complete, USCIS will give you a receipt notice that extends your status while your case is pending. But here's another critical consideration for conditional green card holders. If you plan to file for citizenship using the 3-year rule because you're married to a U.S. citizen, You need to make absolutely certain that your marriage is still intact, you're still living together, and the relationship is genuine when you file that N-400 naturalization application. Here's a scenario I've seen happen, and it's heartbreaking. A couple files their I-751 jointly because they're still married at that time. A year later, before the I-751 is approved, one spouse becomes eligible for citizenship and files Form N-400. But by the time the N-400 interview happens, the marriage has fallen apart. Maybe they're separated. Maybe they're sleeping in separate rooms. Maybe one of them has moved out. When the USCIS officer conducts the naturalization interview, they're going to ask about the marriage. They might ask if the couple is still living together. They might ask when they last saw each other. If it becomes clear that the marriage is no longer bona fide or that the couple is separated, the officer can deny both the N-400 and the I-751 at the same interview. You don't just lose your path to citizenship, you lose your green card entirely. This is why timing is so critical for conditional green card holders. You need to be strategic about when you file your I-751 and when you file for naturalization if that's your goal. You need to be honest with yourself about the state of your marriage. And if your marriage is ending or has already ended, you need to proceed carefully with the right waiver strategy rather than trying to file jointly when the relationship is no longer genuine. Let's recap everything we've covered today because this information is too important to forget. We've talked about 5 critical mistakes that could ruin your green card in 2026. First, if you're already a green card holder, avoid extended absences from the United States. With the new tracking system starting in February, USCIS will know exactly how much time you're spending outside the country, and they will enforce residency requirements more strictly than ever. Start your green card renewal process early if you're approaching the 10-year mark, so you have time to address any issues that might arise. Second, if you're applying for a green card, make absolutely certain you answer the public charge questions correctly on Form I-485. Provide complete and accurate financial documentation and make sure your entry records match exactly what's on your I-94. Mistakes in this area can lead to denials or even findings of fraud. Third, submit complete and accurate applications with all required supporting documents. USCIS is not obligated to give you a second chance through a request for evidence. An incomplete application can be denied outright, costing you time, money, and possibly your immigration status. Fourth, prepare yourself for delays, enhanced vetting, and fee increases. If you're from one of the countries currently subject to additional scrutiny, expect your case to take longer. Don't travel internationally if you have a pending application. And make sure you're using the correct filing fees when you submit your application. Fifth, and most important for conditional green card holders, be extremely careful with your Form I-751. Choose only one waiver category. If you're filing on your own, not multiple categories. Make sure you're fully divorced before filing with a waiver. And if you're planning to apply for citizenship while your I-751 is pending, make absolutely certain your marriage is still genuine and intact. This has been a lot of information, and I want you to know that you're not alone in navigating this complex system. Here at US Info Updates, we're committed to bringing you the latest news, the most important tips, and the strategies you need to succeed with your immigration journey. If you found this video helpful, please do me a favor and share it with someone who needs this information. You might have a family member, a friend, or a coworker who's going through the green card process or dealing with conditional residence. This video could make a real difference in their case. And if you're new to our channel, welcome. Hit that subscribe button right now so you don't miss any of our weekly updates, breaking news, and in-depth analyses of immigration policies and procedures. We work hard to bring you accurate, timely, and actionable information that you won't find anywhere else. If you need personalized immigration help for your specific situation, we're here for you. You can reach out to us directly. We understand that every case is unique, and we're ready to help you navigate whatever challenges you're facing. Thank you so much for watching US Info Updates. Remember, knowledge is power in immigration matters. The more you know, the better prepared you are, and the higher your chances of success. Stay informed, stay careful, and I'll see you in the next video with more critical updates and information. Take care.